Thank you all for joining us today. I'm Matthew Jacober, the practice group leader for Lathrop GPM's Litigation and Dispute Resolution Group. I'm in our St. Louis office, and I'm co-moderating today with my partner, Mara Kohara. She's the practice group leader of the Environmental and Tort Group, and she's based in KC. We have some really exciting presentations lined up for you today. We're going to start with a presentation by our PFAS gurus. They're going to explain to you all the law on PFAS and probably even let you know what PFAS means. Then we'll have our employment attorneys. They'll talk about how to avoid employment litigation in what looks like is the next phase of the pandemic. And they'll touch on some vaccine considerations. Then we're going to end the day with a really wonderful panel of professionals who are going to talk to all of us about a variety of racial and equity issues and how law firms and law departments can collaborate to make meaningful change in this very important area. A couple of quick housekeeping notes before we get going with the program, and I hand it over to Mara. We'd love to have your questions. If you have a question at any time, the chat function, bottom middle of the screen, it will be open all day. Just go ahead and submit your question in the chat, and we'll get to as many as we can. If we can't get to your question, or if you want some follow-up, just let us know, and we'll do our best to accommodate that as well. If you look in the top left-hand corner of your screen, you see that we're recording today, and it'll be available on our website. It'll be posted on the front page by Monday, as well as a copy of the slide deck from today. And you don't need to write all that down because we'll send you an email with the information on where to find that on our page. And please be free to share that with as many people as you think would be interested in it. We have applied for CLE credit in California, Colorado, Illinois, Kansas, Minnesota, Missouri, and Texas. And we'll provide follow-up information once we receive approval for the program from those respective states. Mara?
Thanks, Matt. As Matt discussed, we'll be starting things off talking about PFAS, which is an emerging contaminant that is receiving a lot of national attention and something our firm is very focused on right now. Here at the firm, we have a nationally recognized environmental department that handles the full spectrum of environmental issues, ranging from regulatory advice and compliance counseling to responding to agency inquiries and enforcement, PRP searches and remediation coordination, and litigation, tort defense, cost recovery litigation, and insurance recovery. Our environmental and insurance attorneys here today will discuss the regulatory landscape of PFAS, legal issues, and insurance considerations. We've got Allie Cunningham, who's a partner that focuses her practice on the areas of environmental, toxic tort, and other crisis-related litigation with an emphasis on CERCLA and Superfund. Allie also leads our firm's PFAS practice. Her PFAS experiences include defending multiple plaintiff tort claims, advising clients on regulatory compliance, remediation, and litigation avoidance. Next, we have Matt Walker. His practice includes all areas of environmental law, including litigation, regulatory compliance, and assistance with corporate transactions. Prior to joining the firm, Matt served as Assistant Attorney General with the Environmental Bureau of the Illinois Attorney General's Office, where he litigated matters relating to environmental, land use, and energy disputes. Matt also focuses on monitoring state and federal investigation and regulation on PFAS and helps businesses develop strategies to adapt to regulatory developments. Matt serves as leader of our PFAS blog as well. Last, we have Sarah Linticum. Sarah focuses her practice on insurance coverage and environmental law. Her experience includes representing clients in administrative negotiations with the Environmental Protections Agency and state government agencies, advising clients regarding their regulatory requirements, and also assisting in litigation of environmental claims, including cost recovery and contribution claims under the federal Superfund law. Sarah is also actively involved in our PFAS group. I'm going to turn it over to our PFAS experts now so that they can discuss PFAS environmental insurance considerations, what you need to know.
Thanks, Mara. We appreciate the kind introduction. So we're really excited to talk to you guys about PFAS today. As Matt indicated, we'll even explain to you what it is. Abby, do you want to click forward to the next slide? Perfect. So really briefly in this presentation, we're going to go over kind of what is PFAS, what are PFAS, I should say, and the background for them. Matt will give you kind of the overlay of the current federal and state regulation and litigation climate. And finally, Sarah will talk to you about mitigating PFAS through insurance coverage, PFAS liabilities through insurance coverage. Okay, next slide, Abby. So what are PFAS? That's the million-dollar question today. So PFAS is an acronym that stands for polyfluoral and alkyl substances, or perfluoral and alkyl substances. It's really a class of about 5,000 chemicals that were originally created in the 1930s and 1940s. You'll best know PFAS as the Teflon pan in your kitchen, the nonstick pan in your kitchen. It is basically any chemical that creates nonstick, wrinkle-resistant, stain-resistant, grease-resistant materials. And so it's really ubiquitous. It's prevalent all throughout your household. And in fact, recent estimates say that 98% of the human population actually already has some form of PFAS in their bloodstream, which is a little frightening when you think about it. It was originally created in the 1930s by 3M, and then DuPont also had a version of it. They were commercially known as Scotchgard and Teflon, which will sound very familiar to most of you. They were actually doing a laboratory experiment, and this material appeared on the laboratory countertops and on the floor, and it was a residue that they couldn't remove, and they realized how strong it was, and that's what ultimately led to the creation of Teflon and Scotchgard. So it's very strong, but the fact that it's so strong and so resistant to so many things is what actually makes it also very problematic. So it's been in the kind of stream of commerce for almost 80, 90 years at this point. But what we're just now learning is that it has the potential for adverse health effects. It was actually only a couple weeks ago that the Center for Disease Control came out with a toxicological profile explaining what the adverse health effects are for PFAS. The big ones that are really kind of concerning are potential cancers, particularly kidney or testicular cancer. There's some indication that it can cause vaccine resistancy, which of course has been a big topic in the current global climate. There's some potential issues with pregnancy, including preeclampsia or low infant birth weights. And then the other big one that's discussed is potential impacts on liver enzymes. All of the information on health effects is very preliminary, but what we've heard to date is that even very low levels of PFAS have the potential to cause these negative health effects, and that's what makes it so problematic. The two most widely studied compounds are PFOA and PFOS. Those are, really Teflon and Scotchgard, so you'll hear that discussed a lot. Go ahead and go to the next slide. That's great. Thanks, Abby. So the issue with PFAS is it's used in a lot of different industries. I mean, I've touched on some, but you see it in semiconductor manufacturing, in metal plating and etching. Two that I really want to focus on here are the textiles and paper production. So anybody that has stain-resistant carpet, or you Scotch-guarded your linen couch to avoid red wine stains, you've applied some sort of PFAS compound to that item, and that's what's making it stain resistant. If your husband's really into wrinkle resistant shirts like mine is, that's PFAS that's making it wrinkle resistant. It's in all kinds of household goods and materials in the stream of commerce. The other one that's been really widely studied and discussed is aqueous film forming foam, otherwise known as AFFF. That's widely used at both airports and Department of Defense installations to combat jet fuel fires. So it's considered that almost any airport or Department of Defense, Air Force installation will have PFAS contamination in the area. This slide reflects really just a small sampling of the industries where you see PFAS today. It's used in a variety of surprising places. One that we've been kind of thinking about recently is cosmetics. It's known that PFAS appears in nail polish, it's in sunscreen and other lotions, it's in dental floss. So it's all around you. And like I said, it's probably in your body. We can go to the next slide. Perfect, thank you. So I'll kind of tee it up here for Matt to dive into more of the detail for you, but you know, how did we get here? If this material was created originally in the 1930s and 40s, and you know, we're just kind of now learning about it. So the first issue is the prevalence of it and the ubiquity of it. PFAS compounds are everywhere. They're in your home. They're everywhere in the manufacturing and industry processes. And it's 5,000 chemicals. So, you know, there's a ton of different PFAS compounds that could be used at any point in time. There's increasing public awareness and scrutiny about PFAS, largely due to a lot of litigation, which Matt will touch on in a little bit, but also the film Dark Waters that came out a couple years ago, which represents kind of purports to represent, I should say, some of the issues with PFAS manufacturing in particular. So those companies like 3M that specifically manufactured PFAS. But what's really kind of got us here today is evolving knowledge. You know, we have better testing capabilities than we've ever had before. The testing was not all that reliable until recently. In fact, EPA is still kind of confirming the reliability of the testing methodologies. They promised to come out with approved testing methodologies in 2021. But testing is expensive and it's not always reliable. And so we're still learning a lot about that. I also mentioned the Center for Disease Control only came out with the tox profile a couple weeks ago. So we're still learning about the health effects. There's a lot of information that's still coming to light about these PFAS compounds that we just don't know the answer to quite yet. And then finally, this will be more kind of in Matt's wheelhouse, but the regulatory and litigation liability is increasing. So there's a patchwork of sort of state regulation. There's a big push for federal regulation under the Biden administration. And you'll see that there's quite a bit of litigation surrounding this issue. And so we've created this kind of significant liability. And ultimately, Sarah will explain to you how potentially insurance coverage could address those liabilities. So I'll turn it over to Matt to go into a little more detail about the regulatory and liability issues.
Thank you, Allie. You can go to the next slide, please. And before we get started on the federal and state regulatory environment, I think I just want to underscore something that Allie had said that I think it's really important to take away from this, and that the regulation of PFAS is really occurring in tandem with our development of knowledge about PFAS, whether it's from an economical standpoint, a technical standpoint, the health effects. There's still a lot that we don't know. So a lot of this is occurring in parallel, and that's part of the reason why we're in kind of this evolving regulatory framework for PFAS. Realistically, probably the very intense regulatory scrutiny over PFAS has only occurred within the past 5 years. So that's underscoring a lot of the disparity between different types of regulations at both the state and federal regulation. I think the current regulatory environment can be captured by 3 different categories. First, there's the laws that are preventative, that are designed to keep PFAS out of the environment and out of the stream of commerce. In the early 2000s, PFAS were the main PFAS, PFOA and PFOS, were voluntarily phased out by manufacturers in the United States in connection with EPA. That has now been formalized through regulation. And along those lines, federal law requires that certain businesses for certain PFAS notify EPA before they even begin using certain types of PFAS, generally the long chain PFAS, as well as importing those types of PFAS into the United States. We're seeing a lot of state law development where they are actively banning certain types of PFAS in consumer products, such as food containers. Notably, New York and Vermont have both promulgated bans on all types of PFAS in those types of consumer products. And finally, EPA for the first time, beginning this year, is now requiring regulated businesses who are subject to the reporting requirements under the toxic release inventory to disclose the amounts and types of PFAS waste that they are releasing or disposing. Next, you have kind of the regulatory and compliance types of laws, which are regulating the amounts of PFAS that are entering into the environment. Most notably, in 2016, EPA developed a lifetime health advisory level for PFOA and PFOS. And this is a non-enforceable guidance level. And it occurred at the same time when EPA was beginning a very important nationwide sampling event to just understand just how pervasive PFAS were in the aquatic environment. And the results were fairly shocking. Roughly 6 million Americans were consuming water from public water utilities above EPA's health advisory level. And that's actually now led to proposed enforceable standards, which we expect to see probably sometime this year or early next year. In the absence of federal regulation, states have also begun developing enforceable drinking water standards, which we'll see on the next slide. Additionally, there is certainly an indication from the federal government that we'll begin seeing wastewater discharge limits in wastewater discharge permits for PFAS. We've seen EPA issue guidance about how best to address PFAS monitoring in wastewater discharge, as well as requesting information about the best way to develop standards regulating those wastewater discharges. And some states have even taken upon themselves to begin limiting discharges to wastewater utilities, such as in Michigan. The development of corrective action remedial standards has been a little bit slower, but EPA has developed essentially screening levels for sites that have been impacted by PFAS. Probably one of the most notable advancements is that under the Biden administration, Biden campaigned on the promise that he would regulate PFOA and PFOS under the federal Superfund law. And so we do expect to see that this year. And that will substantially increase EPA enforcement over PFAS impacted sites, as well as litigation among co-defendants. There's been increasing scrutiny over PFAS destruction methods, most notably in the context of incineration. And finally, we're even seeing proposed legislation for medical monitoring for people that have been impacted by PFAS in order to develop a fund that would eventually monitor for latent injury that might occur to those people that have been impacted by PFAS. Next slide, please. As you can see, there is a wide-ranging and patchwork approach that states have taken to develop different types of PFAS standards. And this slide really focuses on PFAS standards concerning drinking water, as well as other water quality standards. And part of the reason for this is that it's important to realize, states have different political climates. They have different priorities. For example, North Carolina has a specific problem dealing with Gen X. And then they have different laws that require them to consider different health effects. So for example, California and Illinois have both determined that PFOA meets the definition of a carcinogen. So that's really underlying a lot of the disparity among the states. Some have adopted EPA's guidance level, that non-enforceable 70 parts per trillion. Some have adopted much more stringent and enforceable levels. And some states are also currently in the process of developing their own wastewater or drinking water standards at levels that may be more stringent than the US EPA guidance. For example, Illinois is developing groundwater standards for a much longer list of PFAS than what US EPA has developed its health advisory levels for. Next slide, please. Much like the wide range of state and federal regulation, there's differences in the types of litigation that we're seeing regarding PFAS, and we've selected a few that are somewhat indicative of the varying types of litigation and regulatory enforcement that we're seeing surrounding PFAS. First, there's the production plated plastic sites in Michigan. This is a former hazardous waste site that was remediated in the early 90s. It was thought to be in kind of a long-term operation and maintenance phase, nearly closed, but PFAS were identified at this site, which has now caused the site to be reopened, resulting in expenses for remediation, having to provide bottled water to local citizens whose wells have been impacted by PFAS, and reopening what was essentially thought to be a closed site. Next, you have the Amazon case in the Northern District of California. This actually concerned false advertising claims, where the plaintiffs alleged that paper products sold by Amazon were compostable, but since they were actually coated with PFAS, they alleged that they were not, in fact, compostable. And that case did settle, but as a result, Amazon actually phased out PFAS-coated paper products from its stores. Next, you have the Campbell versus Tyco Fire Products case. This was a property damage and personal injury case that recently settled for $17.5 million. It was premised on groundwater contamination due to aqueous film forming foams up in Wisconsin. And then finally, you have the Highland Dairy case. This involved a Department of Defense base that was situated next to a dairy, and PFAS contamination from the Department of Defense base had migrated over to the dairy, where the cattle had consumed impacted grass and water. And as a result of that, actually had elevated levels of PFAS in the milk. So as you can see, there's a wide range of different types of PFAS litigation. And now I'll turn it over to Sarah to discuss how PFAS can be addressed through insurance.
Thanks, Matt. So now that we've kind of sufficiently scared you about the ubiquitousness or pervasiveness of PFAS and the variety of litigation that's out there and the size of the damages that can be incurred, kind of wanted to finish up with one asset that's available to you that can help defray the cost and mitigate your exposure, and that's insurance, and specifically the general liability policy. I do want to note that since the 90s, there are environmental specific insurance policies available. This presentation, due to time constraints, isn't focused on that, but that is available. And if your company has purchased that, it's worth looking into. But today, I do want to talk about the general liability policy, and specifically ones that predate 1986, because that is when the absolute pollution exclusion was introduced. The general liability policy itself, they were first introduced in 1941. They are the most widely held form of third-party insurance coverage in the United States. And what that means is that they provide coverage for claims or lawsuits that are asserted against your business. And they provide both a duty to defend and a duty to indemnify. And what that means is that if your company faces a lawsuit or a claim, the insurance company, and that claim is covered, the insurance company has to both pay your legal bills, and then if there is a settlement or a judgment or a verdict against you down the road, the insurance company has to then later pay for that settlement or judgment. Historically speaking, general liability policies have been a huge asset for policyholders in the context of environmental liability, and they will be in the context of PFAS, because as Ali was saying, these, this stuff has been developed or manufactured since the 1930s, 1940s, and the contamination has been occurring since then, but it's gone undetected for decades. And the science is just now finally kind of catching up. And so general liability policies are occurrence-based as opposed to kind of claims-made based. So the policy still responds and provides coverage now when the claim is asserted, even though the damage would have started, decades ago. That's why they're so helpful, and particularly the historical ones that would have been in place and provided coverage long ago, even though the damage or the contamination's been kind of undetected for that long period of time. And so general liability policies generally have two parts. Coverage A is where it provides coverage for bodily injury and property damage claims. And I want to note here that, as Matt talked about, PFAS often shows up as groundwater contamination, and every state in this country has found that groundwater pollution is covered property damage. So Coverage A will be important in terms of providing coverage for PFAS where it's caused groundwater contamination. General liability policies also have what's called coverage B or Part B in there, and that provides coverage for personal injury and advertising liability claims. We tell our clients not to overlook coverage here because depending on the policy terms, coverage Part B can provide coverage for things like nuisance, which has been helpful in the environmental liability policy or context for things like odor claims. So we definitely advise our clients to look at that too. It's particularly helpful because there are courts out there that say the pollution exclusion doesn't apply to that coverage part. So it's nice to avoid that where you can. Next slide, please. But anyways, one thing I wanted to note too is, historical policies can be often difficult to find just because of the nature of the events occurred so long ago. And insurance archaeology is the process that you go through to find or kind of locate secondary evidence of policies that were in existence long ago. And you don't have to limit yourself to just risk management files. You can look in other places that you might not think of. Allie and I recently, she successfully was able to put her hands on some old accounting records from litigation and discovery. And we basically using invoices from like the accounting department saw that there were policy numbers and policy periods and things on remittance, like remittance invoices that showed payment. And we tendered notice to a whole bunch of insurance companies under that, really kind of shooting in the dark. And in response, we were able to get certificates of insurance that showed limits of liability, and we weren't able to get the policies themselves, but it ended up being able to fund the defense of multiple lawsuits. So we encourage our clients to think broadly here. If there were old claims, you can potentially find evidence of policies from defense counsel that would have defended those claims at the time. You obviously can ask brokers to look through their records and see if possibly they would have evidence or old policies. But really you're looking for anything, if you can just find one piece of evidence that will help kickstart you into finding evidence of other policies that might have existed. And again, just thinking broadly is helpful because since this contamination or whatever gave rise to the event, you might not be looking for the company that you know today. It's possible that, their predecessor entity names that would have been named insured under the policy, or you merged with a company or you acquired a company. So look for a policy that might be in a different entity name too. And next slide, please. And then there are certain coverage issues that tend to crop up in environmental liability claims, insurance claims. And one of them is the pollution exclusion. And the pollution exclusion was first introduced in 1973. And then the absolute pollution exclusion was then introduced in 1986, which is why we focus on those two particular years. And anything that predates those is helpful because you can get around them, but there are courts that interpret the pollution exclusion in more favorable ways for policyholders. And so to the extent you can start thinking about whether you have PFAS liability now and finding those historical documents, it's helpful to kind of strategize and think about where you might face liability and whether you can be in jurisdictions that interpret the pollution exclusion in a way that's favorable to you and favorable in terms of coverage, because not every state automatically says that you're barred from having coverage just because there's a pollution exclusion in your policy. And what constitutes a suit? Always look at your policy, look at the terms, and look at how it defines what a claim is. In the environmental liability context, and here as the EPA is looking to designate PFAS or PFOA, and PFOS as hazardous substances under CERCLA, and that is going to probably lead to considerably more litigation. 104E requests or special notice letters and general notice letters and things that aren't litigation yet, but it's an indication that the government has enough information to deem you liable eventually. That can be that can trigger coverage under a general liability policy, and we advise our clients to provide notice early and often, and that's why it's important to look at your policy and figure out when you should be providing notice and how it defines what a claim is. So, one last slide. I know we're running out of time and I don't want to go long. Just this, I wanted to drive home the point here through this nice chart of how long PFAS, and this one shows more of the widely studied PFAS compounds that Ali discussed at the beginning. They've been in existence for a long time, and so they're likely to be in the environment going back even to the 1940s and 50s. So to the extent you can find historical general liability policies going back to the 50s, 60s, and early 70s that don't have pollution exclusions in them, all the better. But they've been, what this is intended to do is show you kind of how long they have been in existence and compare it to when the pollution exclusions would have been put into the policies. So with that, Ali, I think I kick it back to you, or Mara and Matt, but thank you for the opportunity, and happy to answer any questions.
Thanks, guys. And I appreciate that this is actually about an hour to an hour and a half long presentation that we asked you to condense down. So that really good job on that. This is an important piece of our environmental practice, because as you saw just in that half hour, it has the potential to affect so many different industries and so many different types of companies. Our team, including Sarah, Ali, and Matt, are regularly writing and speaking on different areas of PFAS. So don't hesitate to reach out to them if you have any questions. Next, we have Megan Anderson and Neil Goldsmith from our Labor and Employment Group. Megan is an MSBA certified employment and labor law specialist and proactively partners with businesses, nonprofit organizations, and higher education institutions to ensure employment law compliance and prevent legal claims. In addition, Megan works with colleges and universities on higher education and student affair compliance matters. Neil Goldsmith counsels employers on labor relation issues and handles complex employment litigation matters, as well as day-to-day advising questions. Neil has worked with clients across industries including healthcare, manufacturing, retail, food service, agribusiness, energy, transportation, hospitality, and higher education. I've worked with both Megan and Neil quite a bit in relation to the COVID-19 response team, and they were really quick to get up to speed on the COVID issues. And I know that they're gonna be able to give you some really good advice and information here today. Thank you both.
Thank you, Matt. It's a pleasure to be here today. As Matt said, I'm Neil Goldsmith. I'm here with my partner, Megan Anderson. We're both partners in the Minneapolis office of Lathrop GPM in the Labor, Employment, and Higher Education Group. Today, we will be talking about avoiding employment litigation in the next phase of pandemic response, which is certainly a mouthful, but we'll try to break things down for you all and simplify things in the next 25, 30 minutes or so. Like many of you, Megan and I have been spending the last year discussing COVID issues, but specific to employment issues. So what obligations and responsibilities do employers have, and what rights correspondingly do employees have? We've learned quite a bit over the last year, but the hits do keep on coming, and we're still keeping busy in this area. And we're happy to spend the next 30 minutes discussing how to avoid COVID-related employment litigation. So we'll talk about some of the major risk areas, the status of current agency guidance that's going to be relevant. We'll discuss the few relevant published cases that are out there relating COVID-19 employment claims, and we'll talk about some practical guidance on return to work issues as well. So the litigation risks, over 2,400 COVID-19 related suits have been filed just since January of this year. So an incredibly large amount. As you can see, lawsuits are all over the place, and there are a number of different types of claims that employees are bringing related to COVID-19. Most of these claims are safety related or leave and accommodation related. But as you can see, they really run the gamut across a number of different areas. Many of these are falling in the healthcare and manufacturing and warehousing sectors. Some of them very public, including against Tyson, Amazon, other large employers that you've probably seen in the news. But it's really touched just about every sector, every industry, as the COVID-19 complications have as well. So we'll start by talking about employer safety obligations. So employers need to satisfy their legal obligations, not only to their own employees, but other people who they might come in contact with, such as vendors, customers, visitors. And there's a few different laws or areas of law that apply here. One thing you need to keep in mind, the pandemic is not over. Despite what you might hear about, read about, see, there is still risk that exists. Obviously, it's great that the case numbers are lower, the vaccination rates are up, so the risk is lower than it was, but there still is risk. And in particular, keep in mind, we have a number of employees coming back to work and all being in the same space again. So that certainly can amplify the risk if you're not careful. OSHA is the agency and the law that governs workplace safety. There is what's called the General Duty Clause of OSHA, which basically states that employers have an obligation to keep their employees safe while at work. And that's obviously a very good thing. It's good we have that in place, but it's a question of, well, what does that mean in terms of COVID-19? OSHA had issued a lot of guidance over the pandemic, most recently in January. However, as we'll talk about a little bit later on, when the CDC changed its mask guidance a couple weeks ago, OSHA kind of pulled some of that guidance and is actually in the process of issuing an emergency rule, which I just found out about an hour or two ago is going to be released tomorrow. So OSHA is issuing an emergency rule aimed at protecting workers from contracting COVID-19 at work. So be on the lookout for that in terms of other requirements. Workers' compensation, you might know that some states have enacted workers' comp laws that have created a presumption that an employee has contracted COVID-19 at work if they're in a specific industry or a specific job. You've got to worry about general negligence laws as well. Or if you're being negligent and an employee gets sick or an employee's family member gets sick, contracts COVID, could an employer potentially be on the hook? Yes, that's a possibility. Some companies have instituted assumption of risk liability waivers for non-employee visitors. There's always a question on whether or not those things are enforceable. So you should definitely, if you're considering those types of waivers or you have questions about their enforceability, definitely consult with one of your attorneys on that. And they can also just be off-putting generally to the general public or a customer having them sign these types of waivers. There's some business considerations you'll want to think about here too, obviously. You want to develop safety policies that reduce employee refusal or resistance on coming into work, ones that promote good morale and productivity, and think about what does this mean for your reputation? Obviously, certain companies' views on safety and how they're handling things during the pandemic is newsworthy, and if you're doing a good job, you will probably fly under the radar, and if you're not doing such a great job, you might get some unwanted attention in that area. So CDC guidance is great, but it is by no means a silver bullet. And the reason for that is CDC does not have any enforcement authority over employers, right? For those agencies are EEOC, OSHA, Department of Labor, those types of agencies do have actual enforcement power over employers. The CDC does not. But the CDC guidance, of course, is still important. Because if you're following CDC guidance, that can be used as a defense in any sort of safety claim. If someone claims you're not keeping the workplace safe and you're following the CDC guidance, that likely is going to be a good defense. Again, it's not a silver bullet by any means, but is going to be important. So just think about it in common sense terms. What would a reasonable employer do, taking into account its industry operations and worker risks? So think about what are the legally binding COVID-19 prevention and response measures, and that varies by state and local jurisdictions. So make sure you're familiar with those in all the places where your company operates. Obviously, look at CDC, OSHA, and state and local guidance, both generalized and by industry or employer type. Most states have, and the CDC too, have broken down guidance generally by industry. So make sure you're looking at not only the general guidelines for businesses, but whatever's applicable in your own industry. Have a written COVID-19 safety plan. I know that's a requirement in many states as well. And by the way, still is a requirement, so don't completely ditch those quite just yet. And then of course, communicate and train your employees on these safety procedures. So now I'd like to turn it over to Megan to discuss discrimination and accommodation issues.
Thanks, Neil. Yeah, another key area of compliance and litigation risk with COVID has been non-discrimination laws, which, as you all probably know, provide that you can't treat an applicant or an employee adversely or differently in the employment context based on a legally protected characteristic. And then when it comes to a couple of different characteristics, primarily disability, pregnancy, and religion, these laws go beyond kind of the general non-discrimination rule of doing no harm to actually requiring employers to affirmatively grant reasonable accommodations to level the playing field and ensure that people with disabilities or pregnancy conditions or who have sincerely held religious beliefs have equal opportunity in the workplace. And we've seen these kinds of legal issues come up during COVID in a couple of different ways. I'm going to primarily focus on two of those today. The first is that you cannot treat people differently with respect to your COVID policies, protocols, and practices based on a legally protected characteristic. And so an example of where this has come up in COVID is early on when the CDC issued guidance about which parts of the population were most vulnerable to COVID. We had some clients asking if they could then have some specific policies targeted to those populations, but there was a tie-in between vulnerability and protected class. For example, older workers were potentially more vulnerable to a bad COVID outcome, or people with disabilities. People of color have been unfortunately disproportionately impacted by COVID. And it would not be lawful, for example, to adopt a policy or practice that says, we're going to only have our employees who are age 60 or older work remotely, for example. You've got to make sure that your policies and approaches are non-discriminatory. I think the bigger issue that most employers have been grappling with under the discrimination laws have been around those reasonable accommodation issues that I mentioned. There is a duty. Again, it's for disability, pregnancy, or sincerely held religious beliefs to grant reasonable accommodations to ensure equal opportunity, as long as the accommodation is not an undue hardship. And that has come up in a number of ways during COVID. I would say the issues I have seen come up most frequently is that an individual, because of a medical condition or a pregnancy, is at higher risk for a bad COVID outcome. And because of that, they want some form of accommodation. Primarily, we've seen requests for remote work where perhaps employers weren't already doing remote work, or leaves of absence. And then we've seen a lot of requests for accommodations come up around some of the safety measures that Neil was addressing. So a lot of requests for additional safety measures on the job for somebody who might be immunocompromised. So perhaps a more isolated workspace if they still need to come into the office, or plexiglass or extra protective gear. We've also seen requests for exceptions to workplace policies. So, again, Neil mentioned we're here in Minneapolis. We did have a face covering mandate that got lifted recently. And I helped a lot of clients through dealing with accommodations for people who had issues wearing a face mask because of some sort of medical condition or religious beliefs. So it's important to remember that those obligations are out there and that they can be nuanced in terms of complying. If we can go to the next slide, we picked two actual litigation matters to touch on today, though, as Neil pointed out, there's no shortage of litigation out there. One of the cases that we thought we would mention was an accommodation case. It came out of the federal district court in Massachusetts, and it involved a disability accommodation issue where an employer, at least according to the reported facts, didn't handle the situation probably as well as they should have and got sued. So the plaintiff in that case was a manager for an organization that provides social services to vulnerable at-risk populations, and he had asthma. And early on during COVID, everybody was working remotely, but the employer, not too far into the COVID outbreak, took the position that all managers needed to come back to the office setting. This employee provided medical provider documentation about his asthma and the need to work in a remote isolated setting due to his asthma and the risk that that posed for him if he were to get COVID. And initially the employer worked with him for a time and accommodated him, but eventually declined to continue doing that and required him to come back into the office. And in the course of doing that, provided what appeared, according to the court record, pretty limited accommodations around safety. The employee continued to press around his issues, and actually his direct supervisor, wrote in a letter of support that probably was part of the reason for the court outcome in his favor, because his direct supervisor wrote a letter saying that he could actually perform all of his essential duties remotely. The employer continued to insist that he come back to work, and he believed he was going to be fired if he declined. And so what he did is he went into court and sought injunctive relief. He essentially sought an emergency order preventing the employer from firing him, which is not kind of a typical posture for an employment case. In that setting, the court assesses whether they don't make a final decision on the merits, but they do assess the plaintiff's likelihood of success, and they sided with the employee here. If we can go to the next slide, the court found that his asthma was likely a disability, and interestingly, had some language that said it's likely a disability, sort of particularly during the pandemic, but because of the circumstances of the pandemic, he was probably more limited than he might have been normally due to his asthma in terms of his ability to be out in the world doing what most people do. And the court found that the employer had provided a pretty vague, conclusory explanation for why they were making him return to work, which was simply an explanation that all managers, because they were managers, needed to be on site. The employer was found not to have engaged in sort of an individualized assessment or interactive process with him as to whether he could work remotely. And so the court found that he was likely to succeed on his claim. I think the case is just a good reminder that both the substance of what you do and the process really matters. When you get a request for an accommodation, there is an obligation to go through an interactive dialogue with the employee and to make sure that you are basing your decisions on a very individualized assessment of current and actual facts, that you're not engaging in conjecture or speculation or sort of conclusory decisions, that you're actually drilling down to determine what the employee's essential duties are and whether you can either give the requested accommodation, or if there's an equally effective accommodation, that's certainly an option. And the employer didn't do that here. You don't have to grant accommodations that are an undue hardship, but that is a pretty stringent standard and also a very fact-specific analysis. So I always recommend that if you're going to say no, and particularly if the no is going to come with a termination of employment, it's always a good idea to check in with legal counsel. If we can move to the next slide. Another aspect of discrimination laws that have come up a lot during COVID are the limits under disability discrimination laws on when you can require medical tests or engage in medical inquiries, and in particular, disability-related inquiries. Normally, there are some time limits and restrictions on when you can make inquiries and how you can do that. And so one of the questions that has come up repeatedly during COVID is what the rights are of an employer to be making inquiries around COVID exposure or illness, symptoms, testing, vaccine status, and the like. Fortunately, the EEOC, which, as you probably know, enforces our federal discrimination laws, put out some guidance pretty early on that was favorable to employers and said that as long as you are being very narrowly tailored in what you are asking, and you are simply screening for whether somebody has COVID symptoms, a COVID illness, a positive COVID test, or they've gotten a vaccine, but you are not digging down further into their medical conditions or diagnoses, those COVID-related questions alone are not a disability inquiry, and therefore you can ask them, and you can ask them at any time. You do have to keep that data, though, confidential, and under the disability discrimination laws, any medical data has to be stored separately than an employee's regular personnel records. If we can go to the next slide. Another issue that has come up, and I'll try to move through these slides quickly just to kind of keep us on track from a timing perspective. Another compliance issue and potential litigation risk is sorting out when employees have legally protected right to time off due to COVID and when they don't. We've had people who legitimately need time off and are entitled to that. And we've also had situations where, unemployment benefits have been increased at times due to different stimulus packages. We've had labor shortage issues that are continuing where some employees are resistant to come to work. They don't have a protected reason, and the employer really needs to get them back to work. So those are issues you all, I'm sure, have been sorting through. When you're thinking about employee time off, I'll just quickly flag the sources of legal obligations that you need to be thinking about. You need to be thinking about whether that employee might have an individual employment agreement. Most employees don't, but sometimes executives or managers, for example, might have individual agreements with time off provisions. Or if you've got a unionized setting, there might be a collective bargaining agreement. Your employer policies around whether you've granted vacation, sick, PTO, or disability benefits are going to be relevant. You'll need to honor those policies and obligations. There may be federal, state, or local time off rights. At the federal level, we've got the FMLA if you're a big enough employer, and we temporarily had the Federal Families First Coronavirus Act, which has expired, but if you voluntarily comply, I think it's through the end of September, there's still some tax benefits. We also can have state and local family leave rights, and increasingly we have sick leave laws and ordinances around the country that often will apply to COVID. And we've also seen some counties and cities pass specific COVID measures. You want to make sure you know what those obligations are. I already touched on accommodation issues. That's another source of time off. Leave rights can be a reasonable accommodation depending on the jurisdiction that you're in. If we can move to the next slide, I'll just sort of quickly touch on some of the things that are not protected. Not surprisingly, most people in the population have had some generalized fear and anxiety over COVID. Not wanting to come to work, based on sort of that generalized fear that most of us have, is not going to be protected unless somebody's anxiety is so severe that it actually is a disability or a FMLA, serious health condition, or sort of otherwise gives them some medical leave rights. Personally disagreeing with safety measures, and we've certainly seen a fair amount of that during COVID, that is not going to be legally protected. Now, disagreeing because you have a religious belief that's contrary to a safety measure, again, is going to be a different issue. Some of the other reasons people have needed time off that I've seen lots and lots of our clients try to accommodate, but is typically not legally protected, are situations where the employee themselves does not have a disability or compromised health situation, but somebody in their household does, or a loved one does. And so they don't want to be out in the world, and then go home and potentially expose someone. Without going into great detail, those situations are technically not protected under the FMLA or disability laws. But we've had a lot of employers try as best they can, to work with employees who are valued through those situations. And it is illegal to discriminate based on an association with someone else. So it's a good idea to kind of run those situations past legal counsel. If we can move to the next slide, I'm going to turn it back over to Neil, who's going to talk about our second litigation matter that we're highlighting.
Thanks, Megan. And I'm just going to kind of gloss over this because I do want to get to the hot topics of masks and vaccinations. This is the Payne cases out of Pennsylvania. The facts are pretty familiar, I think, to a lot of us dealing in this area, where a person tested positive for COVID. They were ordered to quarantine. 6 days later, the director said, no, you got to come back to work. He says, I can't, I'm still quarantining. This was at the very beginning of the pandemic, by the way. And he was fired the next day. He brought FMLA, ADA, and FFCRA claims. And the big takeaway here, which is interesting, unlike the Peoples case that Megan talked about earlier, this judge in Pennsylvania really didn't put any special lens on this because it was COVID-19 related, and just treated it like it was any other kind of ADA, FMLA type case. And so the big takeaway here was that even though the employee did not specifically mention FMLA leave or implicate that he was looking for FMLA leave, the court said that there was enough of an issue to let it go past the motion to dismiss stage on that issue. So let's move on then to the next slide on face coverings. This news dropped on May 13th, I believe. I'm not sure what everyone's weekend was like a few days later, but mine wasn't the most enjoyable. I was working quite a bit. I had a lot of client inquiries on what do we do? We want to change the policy. Can we do it? Can we not do it? And so, as I explained to clients then, which is still the case now, right? The CDC does not necessarily control, although it's going to be helpful and persuasive if there's some litigation surrounding a mask issue. You still have some problems potentially under OSHA and potentially under Title VII and religious issues and the Americans with Disabilities Act. And that's the issue there is, let's say a lot of companies said, well, we want to make it that if you're vaccinated, you don't have to wear a mask. And if you're not vaccinated, you do. And I know a lot of companies have taken that position. I still think there's some risk in that decision because remember, there are some folks who are not getting vaccinated, not just because they don't want to, but because they have a religious or a disability related reason that they can't get vaccinated. So I could see a situation or an argument where you have folks wearing masks in the workplace because they can't get vaccinated for those reasons and potentially could be subject to ridicule or harassment or questioning their beliefs on why they're not being vaccinated. So there is still some risk in that area. I would just say, tread lightly, be aware of those things, and just be aware of kind of the morale, employee relations aspect of that if you are choosing to implement that sort of policy on masks. Go to the next slide. Again, yeah, just consider, sorry, there you go. Just consider what is reasonable to promote. Also consider if you're going to collect vaccination data, because that often goes hand in hand with the mask issue. For example, if you are differentiating between vaccinated and unvaccinated, make sure you're properly collecting that data. As medical data, as Megan mentioned, needs to be held separately from a personnel file. There's other potential risks if it gets into the wrong hands or is shared to other employees. And then also just make it clear to your employees that retaliation, discrimination, harassment won't be tolerated on mask related issues, whether someone's wearing one, is not, whatever their choice is, whatever the policy is. Make sure it really is conducive to continued positive employee relations. And I'll turn over to Megan to talk about vaccine approaches.
Great. Yep. I'll wrap us up here with vaccines and just a few quick takeaway tips. So we've been getting lots of questions around employer approaches to vaccines and where employers want to promote and encourage vaccines. There's really been three primary approaches. Educate and encourage, which is going to be the least risky, right? That's where you're not really requiring anything. You're just providing good information to your workforce and encouraging them to get vaccinated. Educate and incentive is the other approach where you're going a little bit beyond educating and you're providing some sort of perk, some sort of extra to get the vaccine. And we've seen anything from, extra PTO to cover the time that people need to go get the vaccine, to sometimes, gift cards or some sort of affirmative payment to the employee for getting the vaccine. Or I've certainly seen other perks as well. And then the third approach is to mandate. If we can go to the next slide, the mandate and the incentivized approaches have a few legal risks and compliance issues that you should be thinking about. In terms of whether you would mandate a vaccine, when it comes to federal employment law, it's largely good news that the EEOC has said that it is lawful for employers under our various discrimination laws to mandate vaccines, as long as you do it on a non-discriminatory basis, because you've got this safety duty that Neil talked about. And so mandating a vaccine is going to be, when you look at the disability laws and what's required for requiring medical tests, et cetera, it's going to be job related and consistent with a business necessity to mandate it. But you are going to potentially have to grant accommodations, as we've talked about, for disability, pregnancy, or religious beliefs for that program to be lawful. And I will tell you, the trend that I have been seeing is that while probably a broader group could justify vaccines, we've tended to see employers choosing whether to do this really based on their risk profile. So employers with higher risk operations like healthcare industry, first line responders, childcare, et cetera, where it's harder to socially distance and mask, or manufacturing facilities, right, where it's harder to socially distance. We've seen more mandated programs in those settings than we have by other employers. There's a couple other risks to think through if you're going to mandate a vaccine. One is an unsettled area of federal law. Right now, the vaccines that we have out there got pushed through the FDA on an emergency use basis so that the vaccines could be rolled out quickly. And there's normally a more robust FDA approval process. Because of that, there is a federal law that requires that people, when they go in to get the vaccine, that they're told that they have the right to not get that vaccine if they don't want it. And that has raised some questions around whether then an employer can mandate a vaccine. There's different schools of thought on it. The most conservative approach would be to say, no, we're not going to mandate it because of that law. I think there are arguments, and a lot of employers are relying on these to say, well, that's apples to oranges. What, if we, the employer, mandate a vaccine, somebody still has the right to not get it under this federal law if that's what they choose. It's just that there's an employment consequence. But it's something to be mindful of, and it's so early in the phase that we don't know, to the extent there's litigation, exactly how that will shake out. You want to think about state and local laws and whether there's any ban in a location where you've got employees on vaccines. Some states have laws saying you can't discriminate against somebody for engaging in a lawful activity outside of work. That raises a question about whether refusing this vaccine under the federal law might be protected. So you want to think through those issues. If we can move to the next slide. Another issue with mandatory vaccines is non-exempt workers have to be paid for all of their work time, and all of their work time has to be counted to determine if they've hit any overtime hours. So if you're going to mandate a vaccine, you're going to want to keep in mind that you're going to then have pay obligations for your non-exempt employees in connection with that program. If we can go to the next slide, I'll just briefly touch base on incentives. We had quite a bit of uncertainty until just in the last couple of weeks around whether offering an incentive to get a vaccine made your program an employer wellness program. And there's all sorts of legal requirements around wellness programs, because wellness programs involve disability inquiries that implicate disability discrimination law. So they have to be voluntary, and incentives can't be too big so that they become coercive. And there are special privacy rules. And the EEOC used to have some regulations around this that have been set aside, and we haven't had a lot of guidance around the current state of the land or how incentives for COVID tie into wellness laws. The EEOC finally updated its guidance just in the last couple of weeks, and the good news is that if you are offering a vaccine And the only proof of vaccination that you require to get the incentive under your offered incentive program is proof of that vaccine through some outside provider, as opposed to getting it through the employer itself, then that is not going to be an incentive plan. The theory being that you're not really making a disability inquiry. You're simply asking about vaccine status and taking a quick look at a document to verify that a vaccine was received. If the employer is going to run a vaccine program itself, that could be a wellness program with more complications, and you'd want to check back with legal counsel. If we can move to the last slide, I'm just going to leave you with a few parting tips that we've run over a little bit, and we want to move you on so that you can enjoy the next presentation. We've talked a lot about a lot of things. I would say that, if you're at a point where you've had a lot of folks remote and you're starting to either bring them back or think about bringing them back, you're going to want to think about your workplace culture, your risk profile, your ability to comply in all of these areas that Neil and I have mentioned, and make sure that as you bring people back, you're well set up to comply. You're also going to want to think about your employee preferences. I spoke on return to work issues a couple of weeks ago and gathered some interesting survey results as part of that. And interesting, one of the surveys I found said that for employers where their workers have been largely remote, there was a national survey done of people in that category, almost 70% preferred some sort of ongoing hybrid approach, and almost 40% said they would look for another job if their employer didn't offer hybrid approaches. None of that's legally binding on you, but from a practical standpoint, something to be thinking about. With that, thanks for spending some time with Neil and me and letting us talk with you about these issues. We're going to let you move on to the next presentation. Neil and I are happy, if you have follow-up questions, to have you reach out to us and we can answer them.
Thank you, Megan and Neil. I know so many businesses are grappling with these return to work issues. So this was very helpful and timely. And of course, reach out to Megan and Neil and anyone else in our employment group should you have any questions. I'm now pleased to turn the presentation over to Vanessa Von West. She's our firm's Director of Diversity and Inclusion, and I have been fortunate enough to work closely with Vanessa since she joined the firm 2 years ago, particularly with regards to our Women's Initiative Network, and now I sit on the Diversity and Inclusion Committee that she leads along with others in our firm. Our diversity inclusion focuses on ensuring Lathrop GPM remains a supportive, encouraging environment for all attorneys and staff. Prior to joining the firm, Vanessa served in community relations positions at the City of Olathe and UMB Financial Corporation. And again, we are very lucky to have her, and I'm going to now turn the presentation over to her. Thanks, Vanessa.
Excellent. Thank you, Mara. And we are excited to get started on this diversity presentation. So to start off this important discussion, we have Lisa Kirby, who is joining us from Diversity Lab. Lisa will discuss how the Mansfield Rule Initiative is helping law firms to increase their recruitment and retention of diverse attorneys. And she's also going to talk about the history and evolution of the relationship between law firms and legal departments and how it has impacted diversity in the legal profession. After that, we will have a great panel. I'm very excited to bring our panelists in. They're going to take an even deeper dive into the practical ways to implement diversity and equity initiatives within your company. So let me tell you a little bit about Lisa Kirby. Lisa Kirby brings 20 years of experience in the legal profession to Diversity Lab. She has served as a practicing attorney, talent management professional. She has also been a law firm consultant. At Diversity Lab, Lisa has led the creation and implementation of the needle-moving Mansfield Rule. And Lathrop GPM is now very pleased to be a member of the newest cohort for the Mansfield Rule certification class. Lisa is a very sought-after speaker and prolific writer, and we are lucky to have her with us today. So with that, I will turn it over to Lisa.
Hi, everyone. Thank you, Vanessa, for that very kind introduction. I'm so glad to be here with all of you. And one moment, let me begin sharing my screen so I can get to my slides. And yes, we are so thrilled to have Lathrop GPM on board for the Mansfield rule for this coming next iteration. So I'll talk to you a little bit about the Mansfield rule, but as Vanessa said, I wanted to provide a bit of context first for how clients and outside counsel have been working together towards collective diversity goals, including through the Mansfield rule. So let's see. And yes, I am a recovering lawyer and I lived through a lot of what we're about to discuss. So I had a firsthand experience of this. I thought I'd start with 2 points of quick historic context, just to place sort of the years and the timeline, just to frame that for us as we talk about, sorry that my cat is decided to come up on the desk just now. This first picture is Arabella Mansfield, of course. She was the first woman admitted to, sorry for the chaos, admitted to the practice of law in the United States in 1869, but she wasn't allowed to practice because she was a woman. And of course, the Mansfield rule is named after her. The next picture, can we launch the poll really quick, please? I just have a quick fun poll for everyone. I stumped some of my colleagues and my husband, who's a neighbor, with this poll earlier. So my husband, who's a lawyer, I think I meant to say. Charlotte Ray was the first Black woman to graduate from law school in the United States. She graduated from Howard University Law School in what year? Please vote really quick. That's just for fun. 1872, 1899, 1914, or 1928. And by the way, Charlotte Ray was known for her excellent legal mind. She actually did practice and argue in court. And this was in, if enough people have voted, maybe we can just look at the results. Okay, 1914 was the winner. And actually, I can see why you would think that. And actually, the last place was the correct answer. This is kind of what I predicted, but 1872. She graduated in 1872, just a few years after Arabella Mansfield graduated from law school. So a pretty long time ago. And so I think that's just interesting to consider as we look at sort of the more recent history of diversity progress in the legal profession. A couple other quick data points. Thurgood Marshall was appointed to the Supreme Court in 1967. Sandra Day O'Connor was the first woman Supreme Court justice, and she was appointed in 1981. So fast forward a bit to, oh goodness, fast forward to the 1990s. And what was happening then? Well, the late 1990s, early 2000s, legal departments and general counsel were kind of in the stature in the profession that they are now. Prior to that, they didn't quite have the same standing. Law firms were sort of driving in the driver's seat, but around the 90s, general counsel took on the current influential role and voice that they have. And it was seen that the legal profession was not making progress on diversity and inclusion to the same extent as other sectors of the economy. And in 1999, Charles Morgan, who was the general counsel of Bell South Corporation, led the way and sort of took the initiative to join forces with his fellow general counsels and issued a statement of principle. And this was basically a strongly worded letter letting law firms know that general counsels cared about diversity and wanted to see them apply themselves a little bit more and focus more strongly on diversity. And it's not known whether, and at the same time, many different, as you can see in these little headlines, many different bar associations were issuing pledges or calling on their members to pledge to achieve greater progress in diversity throughout the 90s and early 2000s. So there were a lot of pledges and letters. After the statement of principle was issued by Charles Morgan, it's not known exactly what effect that had in terms of impact and results. We do know that the progress in diversity in terms of representation in law firms remained pretty low, and so pretty slow progress during that time frame. In 2004, the Rick Palmore, who was a prominent Black general counsel of Sara Lee Corporation, issued a call to action. This had it was a little bit more of a strongly worded open letter saying that corporate legal departments would limit or end the relationship with firms whose performance consistently evidences a lack of meaningful interest in being diverse. So it was trying to add a little bit of teeth, although it's not really known what the follow through was from the 200 or so general counsels who signed the call to action. There was a website set up that was meant to sort of gather responses or follow or be sort of a follow-on way to see what was happening. It's not working right now, so I'm not sure. Again, it was meant to send a strong message, and of course, lawyers are used to sending strongly worded letters and expecting to see results follow from them. I think in this case, it didn't necessarily happen because for a couple reasons. One is that law firms at the time believed that the main barrier to diversifying was simply getting underrepresented associates in the door. So their main focus was recruiting and entry-level recruiting. So law schools have been very diverse for a couple decades or more, maybe 25 years. Women have been half of law school classes. We'll look at the stats in a second. And underrepresented racial and ethnic groups have been about 25 to 30% of law school classes for at least the last 15 years. But even back then in the early 2000s, law firms were doing a pretty good job of recruiting classes that were about half women and at least 25% minority associates overall, and increasingly LGBTQ plus associates as well. But there was a drop off from the entry levels up to the more senior levels of a law firm where you really have influence and more of a voice. And the focus, and so it was believed by law firms that simply getting associates in the door was the main effort they should focus on, and that talented lawyers would sort of bubble up to the top through hard work, and their talent would shine through, and they would move up the ranks and sort of take over law firms just as it had always worked before. And they also focused a little bit on mentoring, as did the bar associations, to ensure that everyone was covered by mentoring, not just those who were had social connections or school connections or family connections or affinities or interests that aligned with those in the majority. Again, it's a little hard to tell whether these efforts really ultimately have made a difference, given the fact that the numbers are still so low. And so, we can look back and say that maybe these efforts seem a little bit naive, but at the same time, the concepts of unconscious bias and structural inequalities, even the words inclusion and belonging, were not part of the vocabulary of members of the majority who are making the decisions, even though at the same time, underrepresented associates were feeling it was an isolating and frustrating experience to work in some of these firms, and their attrition levels were much higher than those of their majority counterparts. So that was what was happening then. This is just a depiction of all the different talent practices that need to be examined and evaluated to make sure they are functioning as inclusively as possible. We don't really have time to talk through all of these, but you can see that entry level and pipeline is one piece of it, but there's a lot more to it. Compensation, development, promotion, and so on, all really need to be looked at and debiased to some degree, and their impact needs to be evaluated and measured. So let's go to the next. Oops, I skipped one. The open letter theme continued in a couple of years ago. I'm sure we all remember 170 general counsels sent a letter to law firms again saying, improve on diversity or you'll lose our business. And there also was a lack of defined financial incentives or definitive follow through that sent a strong message. At the same time that this is happening, legal departments have increasingly been sending surveys that have become more and more comprehensive and detailed, meant to gather diversity metrics from law firms, from their outside counsel. And so these started to proliferate. The ABA Resolution 113 was meant to be a one-stop shopping sort of single diversity survey to streamline what had sort of ballooned into a very unmanageable process that was taking a lot of time and resources from firms to answer slightly different questions from many different clients. That didn't quite pan out. The model survey is great, and a lot of legal departments used it as more of a base to work from and adding their own preferences and priorities. So law firms have told me in the past year, some law firms answer over 1,000 diversity surveys in a year. Again, it's not clear what the connection really has been to improving law firm diversity. The most obvious and measurable impact of the increase in these diversity surveys has really been that law firms have needed to devote significant resources towards answering and processing and working through all these survey responses, which all have slightly different permutations of similar questions. So that's been the most immediate impact of this increase in the desire to survey outside counsel. And it's increased frustration. And I would say, we'll talk about this next slide in a second, but during this most recent time frame, the dialogue between legal departments and outside counsel took on a bit more of an adversarial tone, as it seemed like there was frustration on both sides with both gathering information and the slow rate of progress on the legal department side. Those were their frustrations, and then the slight frustration on the law firm side at the volume and sort of burdensome nature of these surveys and the questions about individual timekeepers and whether, how this survey data was being used. Another theme has also been that certain well-resourced and very committed legal departments have devised highly comprehensive efforts to both evaluate, incentivize, recognize, and reward, or punish outside counsel firms who meet or do not meet diversity standards. So these programs have accountability built in, definitely. You're maybe familiar with HP's program, which their general counsel, Kim Rivera, decided to hold back up to 10% of fees from outside counsel that failed to meet their standards. Microsoft is more than a decade into its program. They took the carrot approach and they reward outside counsel with bonuses who meet their diversity requirements, and they've actually reported publicly on some of the results. So we can see that it has worked, and their outside counsel diversity has increased quite a bit since they launched their program. The most recent well-known one is the Intel rule, which states that Intel will end its relationships with law firms that are average or below average on diversity metrics. So, for example, they will not work with firms that have 21% or fewer women equity partners, because 21% is the average across the industry as of the most recent data that we have, which is 2019 data. So that's the Intel rule. And again, being very clear about accountability and follow through, but not every legal department has the resources to develop and customize and implement and administer a program of this scope. So, that's another kind of trend that is happening. Let's see. And that brings me to the Mansfield rule. The Mansfield rule launched in 2017. It was a winning idea from the Women in Law Hackathon, which we at Diversity Lab pulled together to have law firm partners hack Solutions to Gender Equity in the Legal Profession. It measures whether law firms have considered at least 30% underrepresented lawyers for key leadership roles, promotions, and senior level lateral hiring. And a lot of legal departments, it has had a significant effect, actually. We recently published data that was analyzed by our chief data scientist and her team, showing that Mansfield early adopters have diversified their management committees at more than 30 times the rate of non-Mansfield firms, and the racial and ethnic diversity of the partnerships of Mansfield rule firms has increased significantly more than that of non-Mansfield firms, as well as the diversity of various other leadership committees. And the firms report as well that, you know, something like 77% of them reported that their candidate pools were more diverse for lateral hiring since adopting the Mansfield rule. So what is built in, so a lot of legal departments have embraced the Mansfield rule as a way to measure their outside counsel's commitment to diversity, because they know that the Mansfield rule is a rigorous year-long collaboration with Diversity Lab. It requires them to meet certain benchmarks. There's, of course, an external certification process and check-ins throughout the year with Diversity Lab and with the other firms, so that if a firm is participating, it's also in the Mansfield rule, they're participating in a systemic approach rather than one that is focused just on individuals. So let's see. So these are just kind of what I just talked about, but the differences and why I know of about 40 legal departments that either require their outside counsel to participate in the Mansfield rule or benefit or provide some recognition or include them on panels or some sort of advantage to firms that participate in the Mansfield rule. In fact, right before I started this panel, I was contacted by a legal department that wants to add Mansfield rule participation to the way it searches to its internal database for searching for outside counsel. So that has been a major impact of the Mansfield rule. I wanted to look a little bit at the statistics. I don't know why my computer is going so slowly right now. Sorry. Oh, whoops. So I don't think we have too much time to talk through all of this, but this gives you a quick visual on how the numbers have played out and how the progress of diversity has played out over the last 15 years or so. You can see that law school students, these are all racially and ethnically underrepresented law students and lawyers. So law students have hovered around 25 to 30% of law schools during this time frame. And at the same time, you can see that equity partners have only just recently begun to approach the 10% mark, and focusing mainly on equity partners for this purpose, just because being an equity partner is typically a prerequisite for a leadership position in a firm, and it is the position with the greatest influence and voice in the profession. So, and it actually, the picture is actually even, it's different if you break it down more granularly. So actually only 2% of equity partners are Black, 3% are Hispanic, and there are only 3% women of color equity partners. The shaded areas you're seeing for the future are just the sort of range that our data scientists modeled of how things could turn out depending on a variety of factors. So that is, we don't really have enough time to pour over this, but this, you can see the big drop off between associates, which have somewhat tracked at least pretty close to law school students, and then non-equity partners and equity partners. So that is why the Mansfield rule is designed to address promotion to partner and promotion to partner and leadership and governance roles, because that is where we see the lack of progress and diversity. So let's see, these are women law students and lawyers, you can see they've been about 50% or more of law school students for a while, and holding steady at around half or roughly half of associates, and still a big drop off, and only just recently surpassing the 20% mark, when they have been about 40 to 50% of law school students for at least the last 2 decades, and probably closer to 25 years. So let's see. Those are the numbers. And then I think I just wanted to talk quickly about the sort of latest iteration. It's something, so Diversity Lab, I should have said at the beginning, Diversity Lab is an incubator for innovative initiatives to promote diversity and inclusion in the legal profession. And we test out these new initiatives. One of them is this Diversity Dividends Collective. And as you can see here, it is designed to address the power and economic gaps in firms that years of these, the pledges that I mentioned and the open letters have not quite managed to bridge. So it's meant to streamline and standardize the collection of outside counsel diversity metrics for legal departments and make it a little bit simpler for law firms to respond by narrowing it down to 5 questions. And we launched this recently with about 12 early adopter legal departments. We actually just launched this last month, so nothing to report on this so far, but these 5 key metrics are, meant to capture both the numbers and the stats, the team representation, as well as the other inclusive practices that are meaningful, that a lot of firms are participating in. So client interaction, who is leading the relationship or the matter, who generated the work, who is receiving credit for that, and then kind of overall inclusion practices. So again, this is a brand new initiative that we're just piloting, but we'll keep you posted. But this is meant to address some of the shortcomings of the previous well-intentioned efforts from outside counsel to from legal departments to encourage their outside counsel to diversify. And I see a question in the chat from Jim Taranji. Does anyone have a diversity and inclusion dashboard to collect and review their internal demographic data to determine and manage hiring, advancement, and leadership data? Well, part of this diversity dividends effort that I just mentioned is going towards having a dashboard. And a lot of legal departments that are fortunate enough to have a legal operations team or somebody working on that, a lot of them have their own individual dashboards. I'm not sure if that's what you meant, Jim, but so I think, and this is just kind of a very quick overview, this is sort of a nutshell version of what we've just been discussing, but I want to make sure we have time to hear the perspectives of our illustrious panelists. So I'll just say that as lawyers, I know that we all have a special interest and concern for the principles of equity and fairness and justice in the profession. And so I think that if we can align and get on the same page about how to approach these goals and these principles with some accountability built in, we can move the needle further, faster.
Excellent. Lisa, thank you so much for that history and the data that will help kind of frame the rest of our discussion today. I'm going to now quickly pivot us and I'll also introduce our panelists who are going to be joining for the remainder of the afternoon. So first we have Stephanie Greasy, who is Associate General Counsel and Senior Vice President at U.S. Bank. She has been there for over 8 years, managing legal risk and providing legal advice to U.S. Bancorp's Community Development Corporation, the company's tax credit investing and community lending group. Stephanie also engages in the diversity, equity, and inclusion efforts of the business line and the law division, being promoted to a new opportunity as chair of the department's Equity and Racial Justice Council in July of 2020. Welcome, Stephanie. Next, we have Vanessa Sims, who serves as the Senior Vice President and Executive Director of Diversity and Inclusion at UMB Financial Corporation. In that role, she has leadership responsibility to design and consult on the inclusion and diversity strategy at UMB. Fostering an inclusive workplace is essential in her role to equip associates of all backgrounds at all levels with the skills necessary to build knowledge, awareness, and tools to thrive within UMB. Vanessa has been profiled in local media, has served as the panelist on diversity and inclusion topics, and has been recognized for helping to advance diversity and inclusion in the workplace. Then thirdly, we also have Justin Salas. Justin is a commercial litigator at Lathrop GPM in our Washington, D.C. office, and he counsels and represents some of the nation's most prominent franchisors on matters central to the integrity of their brands and systems, including trademark infringement, breach of in-term and post-termination covenants against competition, violations of brand standards, claims arising from pre-contractual disclosures and representations, and vicarious liability issues. Justin participated in the Leadership Council on Legal Diversity's 2020 Fellows Program, a program designed to identify, train, and advance the next generation of leaders in the legal profession. Founded in 2009, the Leadership Council on Legal Diversity is an organization of more than 320 corporate legal chief officers and law firm managing partners who are committed to creating a more diverse and inclusive legal profession. Welcome to all of our panelists. Thank you, Lisa, for continuing with us on this journey. And we will go ahead and get started with a few reminders. Thank you to those of you who completed the pre-survey to indicate topics that were of most importance to you. Those will be the basis for our discussion today. And I want to remind you that the chat is open. So if you have additional questions, we will try to get to those as time allows. And then it's always important to define terms. And so before we get to the insights that we want to share, I wanted to quickly define a few terms for you. Those are diversity, inclusion, and equity. So for the purposes of our discussion today, diversity refers to the unique identities of people and the numbers of that representation. So today we'll be using more of a global definition to include not only race and ethnicity, but also disability, gender, age, sexual orientation, gender identity, and all of the unique backgrounds and perspectives that enrich our workforce and our work environments. So the key word there for diversity, I think, would be probably uniqueness and identity. And as you think about inclusion during today's discussion, please think about that referring to the different feelings and perceptions of being valued and how that is folks are leveraged and welcomed within a given setting. So I like to think of inclusion as the connection aspect of what we do. And then lastly is the inclusion. Inclusion is really an approach that ensures everyone has access to the same opportunities. So equity recognizes that there are advantages and barriers that do exist. And as a result, we do not all start from the same starting place. And where equity begins is with that acknowledgement, and then it takes us to more of a commitment to action. And so when I think of equity, I like to think of access and then process. So with those out of the way, let's jump right into it, panelists. One of the things that we discussed in preparation for this panel was really the business case for diversity and inclusion, questioning whether we are at a point where we have already, based on the great data and past initiatives that Lisa shared, that we've already gotten to the point where we no longer need to build a business case. Are we there or are we not? That's the question I pose to all of you all who are on this webinar today. We're going to put up our first of a few polls and really just asking you, do we still need to build the case for diversity, equity, and inclusion within our workspaces? While you all are responding to that poll, I will invite Justin or Vanessa or really any of our panelists to kind of weigh in on your thoughts for this question.
Yes, good afternoon. This is Vanessa Sims. Thank you for inviting me to this powerful and very important discussion this afternoon. And to the question of, do we still need to build the DEI business case? We do need to build it, and we need to revisit it annually is what, in my professional opinion, the world is changing. So the answer to the question is yes, and What I mean by that is, true enough, there's a lot going on from a social justice perspective, lots of change, lots of challenges going on in our country and in our world and our communities. Those should not be ignored if you want to attract and retain talent and customers. The value of the business case is that it helps high-level leaders, boards, and other stakeholders, evaluate the benefits of diversity, equity, and inclusion from a bottom line and financial perspective. So it must focus on the company approach and how we make money, how we save money, or how we achieve organizational goals. However, monetary reasoning is not going to be the only function. So having a business case for the diversity, equity, and inclusion means that we not only help the organization value different people, it has to evolve to helping the organization be perceived as valuable to different people. So not only valuing different people, but being perceived as valuable to different people.
Thank you for that, that excellent nuanced definition there and rationale. So let's take a look at the poll, and it looks like folks are in agreement that we still have some work to do. 75% of you indicated that was the case, and so hopefully you will receive some tools during today's panel to advance that process. Justin, I don't know if you wanted to weigh in, anything else on this question?
Yeah, look, I think, I do think that there's a place for continuing to build a business case for diversity, equity, and inclusion initiatives. I think, I come from a position of we have to be careful about how we define the business case. Lisa, well, from a law firm perspective, I think making the business case has become easier, right? As purchasers of legal services have started to demand accountability from those from whom they're acquiring legal services in the space of diversity, equity, and inclusion. So in that respect, it is becoming easier from law firms' perspectives to make the business case for diversity. And I think the reason that we talk about the business case is because we want to see buy-in into diversity, equity, and inclusion, or DE&I initiatives. And the conventional wisdom, I think, is that one of the best ways to get buy-in is to make a business case for those kinds of initiatives. Again, I think it's in some respects becoming easier for law firms, but as I started my comment, I think we have to be careful about how we define the business case. I think one of the risks is defining it too simply, which is to say, if we increase the number of diverse employees at our organization, we'll see a benefit to the bottom line. I'm not sure that it necessarily works that way when you look at the data. And so we have to be careful about setting that as the business case, because the risk you run is if you don't see that come to fruition, then you lose, the primary basis within your organization for getting buy-in into DE&I initiatives. So I think organizations need to be careful about taking a more nuanced approach to an understanding of the business case. And that's to understand it's one thing to increase the number of diverse professionals within your organization. It's another thing to create a space where they feel empowered and where they feel included to bring them their whole selves to the table and to really tap into the benefits of diversity, where you start to then see the business case being made.
Yep, that's right. And as we think about, that commitment to the nuanced and careful approach to the business case and how foundational and fundamental that is to where organizations are, I think we have to acknowledge that as we look at our goals for DE&I, getting there is not something that happens overnight. This is a multi-pronged, multi-stage, process that takes some time. And so now we're going to just kind of take a look at what that looks like. There's a continuum that many of us in the field have begun to utilize from Deloitte that sets forth some stages. And so I'm going to ask our tech friends to put that up This is a model of diversity and inclusion that kind of charts what that path looks like in the workplace. And it's based on a survey of about 245 global organizations and more than 70 client interviews. It really presents these four levels of maturity when it comes to describing the evolution of diversity and inclusion from the compliance phase all the way through the strategic focus. And so as you are looking at this graph and kind of looking at the poll, I want you to take a moment to reflect on where you think your organization is in this continuum. Are you at level 1, 2, 3, or 4? I remind you that your responses are anonymous and we're just going to show reflective aggregate data. But as you all are answering that, I'll turn it back to Vanessa Sims, who is going to talk a little bit more about just the process of advancing through those stages and her experience with that through her work.
So when we look at the diversity and inclusion maturity model from Deloitte, there's 4 levels: the compliance, programmatic, leader-led, and integrated. So when you think about compliance, it's more like doing just the minimum, whatever's required by law, sort of like a checking the box kind of approach. Again, bare minimum. Programmatic, or if you want to use the word conventional here as well, looks at increasing representation of specific demographic groups, women, LGBTQ, etc. Okay. So just looking at the numbers and having a program or a specific course, maybe training that will help us understand more about diversity and inclusion. But when you get into more of the meat and more growth, you want to move into the leader-led level of this particular model, where you're leveling the playing field for all employees by addressing systemic cultural barriers, developing a business case. The plan becomes more transformative. Leaders ask and expect diversity and inclusion, as opposed to looking to HR to initiate it. So you're getting a little bit of a transformation where the leaders are now saying, hey, this is what we're expecting, this is what we need, and we want it to be more than just an HR initiative. And so when you think about that, it could be things like you're looking at your sales and your marketing teams, communications teams, to make sure everybody is culturally competent so that we'll have greater impact. So training can go and should go beyond awareness to focus on skills that employees can begin to use immediately and apply on the job. Again, it's not just getting that education, but now we're looking at how people are expected by our leaders to apply it in their day-to-day. And when you look at the last level, the 4th level on this particular chart, and there's going to be a 5th one I want to kind of talk about that's not represented here. The 4th level is integration, where we're leveraging difference to create the business case and integrating DEI practices in everyday business operations, setting DEI goals that are really more intricate. And then the responsibility for setting and achieving those goals spreads throughout the enterprise. So maybe we look at pay increases and bonuses are being linked to goals and goal achievement by department leader based upon DEI objectives that were previously set. So again, it's not just checking the box. It's starting to look at, okay, we're integrating this into every part of our organization. Everyone is involved. Think about supplier diversity. That's one thing that we have started to do in our organization at UMB. We have a supplier diversity program that was rolled out a few years ago. We're now doing more training. We're setting more specific goals. We are having road shows to our different lines of business, looking at, opportunities, procurement opportunities are going to be coming up in the near future, and presenting the business case for looking at supplier diversity. We can save money. We can be investing more into the community, into our communities by doing business with diverse suppliers.
Yep.
The level that I wanted to throw in here at the end real quick is more called an advanced stage, where we're integrating DEI into corporate growth strategies. So maybe instead of just looking at supplier diversity locally, if you have the opportunity, look at it from a global supply chain perspective. So I just wanted to add that in there as an opportunity to look for more advancement.
Yeah, so let's see where folks are. It looks like the majority of people are landing in the level 2. And so don't be discouraged by that at all. This is a journey. And what that indicates is that you have begun to build the foundation of your DE&I programs, which is great. I think that level 2 is kind of where you're beginning to ramp up and beginning to ask a lot of those difficult questions. Vanessa walked us through the details of the stages. And unfortunately, we don't have additional time to spend on this graph right now, but when we follow up, we're going to send some materials that go even deeper, explaining what you can do to advance within the different levels and stages, and what that looks like from an HR perspective, from a leadership perspective, with some really useful tools that you can employ within your business. So next, I'm going to turn us to this question of belonging, and I'm going to bring Stephanie Greasy into the fold here as we think about having a diverse workforce in itself does not automatically mean that we have an inclusive culture. That's something that we really have to build intentionally. And Stephanie, when we were having kind of our pre-planning, you brought up this idea, which I think was really salient, about decentralizing whiteness. Can you talk a little bit about that and how that helps to kind of shift the focus and bring us to belonging?
Oh, sure. So thanks so much for having me today. When I think about decentering whiteness and thinking about some of the comments you made at the top, Vanessa, it's about taking the what's been normalized out of the center, right? So that's whiteness, that's maleness, that's Christianity, that's kind of cisgendered, able-bodied, all of those things. We've oriented society around those identities. And so what I have seen in the work that I've done is that we end up in diversity work seeing kind of two definitions of success. We have the definition of success in this work that makes white people look good, right? That you're signing up for the right programs, that you're getting the right external recognition. And then there's a whole other body of diversity work, just to be real generic about the term, that actually results in progress for people of color, LGBT community, women, et cetera, like we talked about at the top. And so to shift from external awards and rewards and recognition to meaningful progress, we have to shift away from thinking about what success looks like for white people who have traditionally been setting the rules, defining success, establishing progress and all of that. And so I think when we do that, that's how we get to the state of belonging, the things that Justin, I think, was talking about really creating meaningful representation. And so a few examples of that in what I see in our work, thinking about the supplier diversity piece that Vanessa just mentioned. We got two Vanessas, so Vanessa Sims just mentioned about supplier diversity, right? We at US Bank have traditionally thought of diverse law firm suppliers on kind of a transactional basis, right? We need a minority-owned firm because we're doing a deal in the city, or there's some special relationship where on a transactional basis we reach out, we engage, and then go back to our relationships with large white-owned firms. That's not creating belonging, that's not creating investment. So what we're really trying to do there, and it's hard, but I think it's going to be really impactful, is to think, what do Black-owned firms, women-owned firms, LGBTQ firms, what do they need from us as a 70,000-person organization to be successful? What do they need from us pre-engagement? What do they need from us at the top of the engagement? What do they need from us throughout the engagement and then after, so that that experience is meaningful, that we start to build the relationship, and that they feel like they belong as part of our approved counsel process. So that's an external facing thing. I think when we think about progress and activities and things that we do in the law department at the bank, we have to ask those same questions internally. Is this program meaningful for people of color? And it comes up a lot in programs around allyship or implicit bias. Whether the programming says it or not, those programs are often designed for white people. delivered by white people, written from the perspective of white people to help white people move along the path. And that is important work, but it is damaging to people who do not identify that way to sit in those rooms and listen to those stories and kind of watch that learning. That's damaging. And so decentering whiteness in that space would be like, what would it look like to create learning opportunities for people of color? What would it look like to create special like discussion spaces for people of color in our organization to talk about these issues in a different way than white people talk about it? So those are kind of internal, external ways I think about belonging, and the way I think about decentering whiteness that I hope will be helpful for folks. And real quickly looking at that poll about where your organization falls on the spectrum and thinking about belonging and thinking about decentering whiteness, how might your answer change if you were thinking about that answer from the perspective of a person in your organization who's from a marginalized community? So how might a person rank your organization if they were Black, if they were LGBT, whatever identity? Like, how does that answer change? That is a quick measure for belonging and representation in your organization. So hopefully that got to the question, Vanessa.
For sure, yeah, excellent reflection, and I appreciate that you were asking us to really kind of shift that lens to look at this from a new perspective. So thank you for that. I want us to talk a little bit about today's world. It seems to me like there is a diversity issue in the news, if not weekly, daily, and what's happening in cities, towns, even countries afar often has an impact at home and impacts the people with whom we work. For example, some of us have lost family members during the COVID-19 pandemic. Some of us were intensely, aggrieved by what happened to George Floyd and related events. And still others of us are reeling from the and feeling scared from the actions of hate and violence towards ethnic and religious minorities. So when those things happen, I'm wondering, panelists, what we can and what we should do to support the trauma of our coworkers during those times. Anybody can weigh in on that, but what do you all think?
Yeah, I think historically there has been a reluctance among organizations to confront these kinds of issues. I think as they have historically been seen as being separate and apart from the workplace. And in some respects, I get that. But on the positive side, I think what we've seen with some of the recent events that you've highlighted, Vanessa, is an increasing desire and willingness by corporations, businesses to take public stances on these issues and bring the discourse into the walls of the business. What has caused that? I don't know. I think it's a positive trend. I suspect in part what has caused it is for the last year, the four walls of the business have not been the four walls of the business. A lot of us have been working from home, and somehow our personal lives have felt far more integrated with our professional lives. And then look, I also think that, as you mentioned, some of these issues are in the news, or it seems like on a daily basis, some of them really quite public and graphic and egregious, which is in many respects forced the discourse. I am hopeful that this trend of confronting and discussing these issues continues. I understand the reluctance to confront these issues because they're difficult conversations. But what I would say is that not everyone within an organization has the ability to decide when, how, and on what terms to confront these issues. Some of the diverse members of your organizations live with these issues on a daily basis. They can't leave them in their car when they pull into the parking lot for work. They can't leave them in the elevator. They bring these issues with them, these concerns with them, these fears with them, anxieties, anger with them, and they carry around them with them at work. And so I think it goes a long way for organizations to acknowledge that as we talk about creating environments of inclusion and belonging. this positive trend towards addressing these issues in the workplace goes a long way to acknowledging what some of our colleagues are going through in creating environments of belonging and inclusiveness.
Yep, yep. And how can organizations ensure that when they are reacting and engaging based on what's happening within our world, that they are doing so in a way that is authentic and reflective? So many times we hear that sometimes corporations issue a statement that is just that, a statement that is empty. How can we guide folks on making more authentic, impactful, and reflective? How can they do that in those moments?
So as part of my new role in the law department, I have been asked to lead the drafting on more and more of these statements. And I am hyper aware of kind of the black tax, right, or the burden that is put on people of color to do all of the explaining. At the same time, I want to make sure that that voice is heard. And so what I do, we're of course going to have something about Juneteenth for next week. I reached out to some of my Black colleagues and I said, what would you like to hear in this? What kind of message would resonate for you as we talk about Juneteenth? What should we cover? Are there other things that we should cover? What would be meaningful for you as a person to bring that in? And so that's one way to handle it. Again, be sensitive to not put it on people to do the work, but what would you like to see? How can we make this meaningful for you?
Yeah, I think getting that input is critical and it really kind of touches into the point that you made earlier about how does this really impact the underrepresented folks and, what are their viewpoints? Excellent. So sometimes, unfortunately, there are missteps, whether it is with the corporate sentiment or whether it is the inadvertent microaggression that happens outside of the meeting. Sometimes there are missteps. And so when those happen, they can most certainly impact our internal culture, and they can also, to some degree, if they are featured in social or other media, impact our external culture and our external reputation. And so I'm interested, panelists, in what your guidance would be of how people can fix that, either as individuals or as an organizational entity.
Well, I'll jump in here and just quickly say, admit it. If there's something that someone has said, this has been offensive, or you're seeming complicit, we're not doing anything, or we've made a mistake. Listen, first of all, to what the individual or the group is saying, non-defensively. Just listen and take it in and learn from what it is. Better understand why whatever behavior or action is was offensive, and it's because it's not about intent, it's about impact. So we have to remember that. It's not what we meant, that's not what we intended, but it's about the impact. So we have to admit it, learn from it, and then take the steps to find out what it is that we can do differently, what we can do better next time to prevent ourselves from stubbing our toe. This is a growth process. We haven't arrived, so we will learn along the way. So and making sure we're doing that learning and then taking steps to demonstrate we are doing better.
Excellent. Any other thoughts on that one? Okay, well, we are coming up on time, so I have one final question for all of our panelists to answer, and that is about our obligations and accountabilities within the industry. So Lisa, in her opening remarks, talked about this is not a new thing, where general counsels, where other leaders have been calling for action within the legal industry in improving diversity, equity, and inclusion. What is our obligation? What can we do? What is most critical? And how can we hold ourselves accountable to really have an impact? Let's see who wants to begin. I will turn it to Stephanie then.
I even looked away, Vanessa.
Oh, sorry.
Slightly looking away at my notes, maybe she won't see me. No, I'm just kidding. There are so many things, how do you cram this into the end? There are so many things, but I think the one tip that I have given in previous panels on this topic with respect to in-house counsel relationship with law firms. Let us see your associates. Let us see all of them. Let us talk to them. Let us meet with them, because that shows a lot of different things. It shows a commitment on your end to mentorship and development. It shows a commitment to retention. It shows a commitment to succession planning. And if you're able to do that in a representative way on top of it, it creates a better experience for us, because we know that we're not just relying on one person at your firm. It creates a better experience for that associate. And it has kind of an exponential effect, because that person grows, they grow in your firm, they contribute more to your firm, they then have access and confidence to work with other people. It shows so much, and it's just a really important thing that we can all do together. So I would say that.
Excellent. What about you, Justin?
Yeah, look, I'd say hold your organization accountable. If you believe that this stuff is important, which I think it is, and probably anyone who is participating in this webinar believes it is, hold your organization accountable. Ask your organization, what is it doing to address these issues? And I think a part of holding your organization accountable is holding yourself accountable. What are you doing to help your organization get better in this space? So that those would be my parting words.
Excellent. And I know, Vanessa Sims, you're not technically in the legal industry, but you have great experience. And so even just to advise organizations generally, what would you say in response to this question about accountability?
Yeah, I would say, I know we've heard this statement, get comfortable being uncomfortable. You know, this is real. We have to look ourselves in the mirror and be willing to commit to take action. And then to Justin's comment about accountability, but then be transparent about it. Share with our associates, our employees, our external partners what we're doing, and hold ourselves accountable in that respect as well.
Excellent. Well, with that, I will go ahead and throw it back to, I believe, Mara, who is going to wrap us up. I do see that we have some questions in the chat, and unfortunately we are at time, but like I mentioned, this is being recorded. We are also going to follow up with some additional resources. We're going to try to answer those questions in the follow-up materials that we send. So thank you so much. And Mara, I think you're going to close us out.
Thank you. That's all I'm going to say. Exactly what you said. We appreciate everyone attending today. We look forward to you all attending our upcoming, we have 2 more sessions. And to our panel members, thank you. We appreciate it. And I think this was very informative. So thanks all.